Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to talk about that confusing three-day rule, the three-day rule. Someone passed along to me an article out of a Boston newspaper, I believe, the Boston Globe. And in it, the guy who's writing the article confusingly tells a story about somebody who got kind of screwed over by a misapplication of the three-day rule. And someone sent this to me and said, Steve, is this true? And I read it and I'm like, wow, someone doesn't understand the law. So here's the situation. I've done other videos before on when you have a 3-day right to cancel a contract. And there is a very, very small set of circumstances where you are allowed to cancel a contract if you do it within 3 days. It almost never applies to automobile sales. So that's the most common phone call I get. But it does sometimes apply to sales that take place in your home. A salesman comes to your home and makes you buy something from them while they're standing in your living room or other home room in the house. Doesn't have to be the living room. We just use that as a cliche. So I'm going to explain to you the problem these people had over there on the East Coast and explain to you what the reporter got wrong, and then I'll explain to you what the law is, okay? So the headline says, letters sent too late. Old rules stymie couple trying to cancel contract. It's not the old rules that stymie the couple, okay? The rules are fine. But according to Sean Murphy, Diane and Leo Walburn were denied a refund because their cancellation letter didn't reach National Floors Direct in time. And that might be true, but on February 18th, Leo and Diane Walburn signed a contract to buy about 700 square feet of carpeting from the company. Within 24 hours, they changed their minds and they called to ask for a refund of their $1,100 deposit. They were told they needed to cancel in writing, so they say they mailed a letter immediately. But the company denied the refund, saying the letter arrived after the 3-day window for cancellation. So it appears they're out of luck, apparently to an ambiguous, outdated form letter that says you must cancel by mail or by telegram, even though Western Union hasn't sent telegrams since 2006. But you have to understand that when you have a series of things and there's an or in there, you don't have to use them all. You only have to use one. So it could say send a letter, send a telegram, send a Pony Express, send a message in a bottle, or use those lamps that they use on board ships, or use smoke signals. Any one will work. Well, the first one was use a letter. Why not use the letter? Just because it includes the telegram as a possibility doesn't mean you have to use a telegram. It says you can use a letter. Why not use a letter? Okay? So don't blame the outdated law because it mentions telegrams. The Walburns do not deny that their letter arrived at the company's office after the 3-day cancellation period, but they wonder why National failed to underscore that the letter had to actually reach them within 3 days, in which case they would have overnighted it. Well, that's not the law. And that's not the problem here, okay? The problem here is that the law says you've got to mail it within 3 days. It's got to be postmarked within 3 days. And they're expecting the company to explain the law to them over the phone, which they're not required to do. The company's required to give them a form that says, here's how to cancel. But if you don't follow that form explicitly, and you don't have to use a telegram, if you don't follow that form explicitly, then you're out. And so when you call them and ask them, how do we cancel, it's in their best interest to not tell you. They don't want you to figure it out. So they're going to tell you something stupid like, oh, if it's not received here within 3 days, you're out of luck, or whatever. But that's not the law. So at the center of the dispute is a one-page letter that sellers like the company here are required to furnish to customers who sign contracts in their homes. It was drafted by the Federal Trade Commission almost 50 years ago, according to this author, and it apparently has never been updated, which is part of the problem. Well, it's part of the problem perceived by this guy. It's not part of a problem that's perceived by anybody else. While the form is straightforward in advising consumers they may cancel without penalty or obligation within 3 days, the actual mechanism for doing so is less clear. No! Mail it within 3 days. How hard is that? Mail it within 3 days. 5 words. To cancel this transaction, mail or deliver a signed and dated copy of this cancellation notice or any other written notice or send a telegram, it says. Yeah, the telegram thing is stupid. But again, like I said, it could have said or send a telegram or use the Pony Express or tie it to a rock and throw it over the wall of our fortress. Or. But the form letter is silent on whether it is the mailing or the receipt of the mailing that must occur within 3 days. Well, that might be a problem with the letter, but the law is as long as it's postmarked within 3 days, you're good. Now, the writer here writes, obviously the form letter should make plain that it must be in an envelope postmarked no later than midnight of the third business day, which my research shows is the actual rule. Yeah, that's the rule. And the only one that makes sense since the sender has no control over the pace of mail delivery. Yes, okay. Now we've got to the heart of the actual law here as opposed to this stuff about how confusing it is when in reality it's actually straightforward. During that first attempt to cancel by phone, which does not count because it's not on the list, the Walburns had asked the company to accept their notice by email or fax. Nope, 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 said the company. Yeah, because email's not a proper form of doing it, and neither is fax. And again, even though I jokingly said it was, Pony Express wouldn't work either. And if you tied the note to a arrow and lit the arrow on fire and fired the arrow through the window of the president of the company and stuck it into the wall behind his head to where it went twang comically and he heard it, that wouldn't count either. Okay? Imagine how crazy this world is when the law says you must mail something and they won't accept an email. Imagine that. The wife of this couple then sent the notice by certified mail. She has a receipt showing the letter was posted on the 19th but didn't arrive until the 27th. Well, the 19th is fine, but when did she sign the contract in her house? Well, it says here that they signed the contract on the 18th. So if she posted the letter on the 19th, she did it. She did it properly. So it says here she waited 10 days to receive a refund, but of course it never came. When she called again, the company said her late notice disqualified her for a refund. Well, that's not true. If she notified them timely, she's good. You're out of luck, too bad, she says they told her. Now, the author of this article, the journalist, wrote, I made a half a dozen calls to the company trying to get them to tell me exactly how they justified refusing a refund, and I told them about the research I had done. They also declined to give me an email address. That might be your problem. You're doing business with a company that doesn't have a website. Okay, now, no law requires a company to have a website. But a company nowadays that does not have a website probably is not somebody you should do business with. But at first, they seemed confused, insisting the company had not cashed the couple's check. But when I asked the wife about that, she emailed me a copy of the canceled check and a page from her checking account showing the debit of $1,111. In the end, the company chose not to discuss this case or its policies with me, saying the matter had been referred to the company's lawyers. I also called the Attorney General's office in New Hampshire, where the Walburns live. They took my information but never called back as they promised they would. I know from the AG's website that accepts consumer complaints but doesn't represent individual consumers in disputes. That's true in most states. The couple are 67 and 66 years old. They moved from Woburn to a house near Lake Winnipesaukee a couple of years ago, and the husband converted the basement into a family room, and they called this company for carpeting. A sales representative came to their home, quoted one price, and offered to knock off $800 if the couple signed right then and there. They agreed on $3,300 with $1,100 due immediately. The company insisted on a check rather than a credit card, and the next day, the company, another carpeting company arrived, and had apparently a better deal that the family wanted, so they tried to then back out of the first deal. And the author of this article points out that the carpeting company never actually installed anything as of this dispute. So the author of this article said the couple may have to go to small claims court. And then the author writes, years ago I won a small claims judgment against an auto dealership that I felt had wronged me. The dealership apparently thought better of spending money on a court fight with me. I won because they never showed up. I hope this couple gets the same result. So here's the thing. The author of this article claims that the law is confusing because it says you can mail or you can telegram, and telegrams don't work anymore. The mail still works. So if I told you you've got two viable options here, one works and one does not, you wouldn't say, hey, there's nothing I can do here. No. One works, one does not. That one doesn't work. That's stupid. No, but that one does. That one does. And the law is quite clear. If it's postmarked within 3 days, you've done it right. So what's happening in this case that's confused Mr. Murphy of the Globe is not the old rules that stymied the couple. The couple dealt with a hard sell salesman who sold them stuff in their house. That's subject to the Federal Trade Commission's cooling off rule, and it would apply in this case. The law is quite clear that if you notify them within 3 days and notification is postmarked within 3 days, then the deal is off. The problem is that no one's going to step in like Superman and enforce it for you. It'd be nice if a reporter from a newspaper could step in and shame the company into doing the right thing, but not all companies are shamed by these things. So it's going to happen here. One of two things. If the company sues this couple for the rest of the contract, the couple can defend it by saying, we canceled, they get nothing, and we want our money back. And if the company doesn't sue the company can sue in small claims court, and it's a slam dunk winner. Game over. That's how many disputes in this world operate. So if someone rips you off, and you are completely 100% right, and the defendant who stole your money is 100% completely wrong, you don't call in a reporter and go, our laws are confusing. This situation's crazy. I called him on the phone, and he won't give me my money back. Bad people often don't give you your money back. You often have to sue them. That's why the courts are there. That's why the courts are clogged, okay? So don't blame the old rule that was stupidly written 50 years ago and mentions telegrams. Okay, it mentions the mail also. Here's a Federal Trade Commission site describes the law. The FTC's cooling off rule gives you a 3-day right to cancel sale made at your home, workplace, dormitory, or at a seller's temporary location like a hotel or motel room, convention center, fairground, or restaurant. It also applies when you invite a salesperson to make a presentation in your home, but not all sales are covered. And it talks about how at the time of the sale, the seller must, by law, tell you about your right to cancel at the time of the sale. The seller also must give you 2 copies of a cancellation form and a copy of your contract, and the contract should be dated, show the name and address of the seller, and explain your right to cancel. But this is all in the contract, okay? No law says they've got to explain it to you verbally, and no law says if you call them on the phone, they've got to sit there and explain it to you either. This is the good and the bad about laws. When a law is written down someplace, okay, that makes it good, okay? But you're also limited to what's written down, okay? So there are exceptions to the rule. It doesn't apply to the contracts under $25. It doesn't apply to contracts under $130 made at temporary locations. It only applies to goods or services primarily intended for personal, family, or household use. It doesn't apply to online or mail or telephone sales, and so on and so forth. And it also exempts real estate, insurance, securities, automobiles, or vehicles that are sold at temporary locations if the seller has at least one permanent place of business. So there's a bunch of things that are out, okay? But here's how to cancel. It's on the internet, how to cancel. You don't have to give a reason for canceling. You have the right to change your mind, to cancel a sale. Sign and date 1 copy of the cancellation form. Mail it to the address given for cancellations, making sure the envelope is postmarked before midnight of the 3rd business day after the contract date. Saturday is considered a business day. Sundays and federal holidays are not. That is about as clear as it gets. And you mail it to the address. Now, the fact that somebody said you can telegram, hey, it's funny, but it doesn't mean that this rule's outdated. I mean, mail is still good, isn't it? I used the mail yesterday. I think it is. And then it says, if you cancel your purchase, the seller has 10 days to cancel and return any check you signed, refund all your money and tell you whether any product you still have will be picked up, and return any trade-in if there was one. And within 20 days, the seller must pick up the items left with you, if any, or reimburse you for mailing expenses if you agreed to send them back. And this is, if you received any goods from the seller, you must make them available to the seller in as good condition as when you got them. Now, here's the problem. It says, if you have problems, you may file a complaint with us, the Federal Trade Commission. You may also wish to contact your state attorney general or local consumer protection agency. Or you can call and complain to the guy at the newspaper who's going to make fun of the telegrams. That'll help. If you paid for your purchase with a credit card and a billing dispute arises, you can notify your credit card company you want to dispute the purchase. And you may withhold payment of the amount in dispute, but only until the dispute is resolved. You are still required to pay any part of your bill that is not in dispute. And to protect your rights, you must send a written notice about the problem to the credit card company. But you'll notice it does not say, oh, and by the way, if a dispute arises and you call them on the phone and they don't explain to you your laws properly, that someone's going to come in and help you and shake these people by their ankles and get your money back. No. It's going to involve you probably going to court, probably hiring an attorney. Some states, like Michigan, has got a thing called a Home Solicitation Sales Act that parallels this. And some states have got laws that actually say if you have to take these people to court to get your money back, you can sue them and get your attorney fees and court costs paid. Okay? So the point is that next time you have a legal problem, this is my advice to you, my friends. Next time you have a legal problem, call an attorney. If you call a reporter, even if they write a story about you, it's kind of cool. I have people say all the time, Steve, let's call the reporters. They'll do a story on this. We can shame them. Yeah? Okay. Can the reporter get your money back? Possibly. I mean, I've seen those stories before. After we contacted them, they agreed to give the money back. But the reporter can't force me to give the money back like a judge can. I mean, a judge can actually enter a thing called a judgment. And the judgment is good, and you can turn that into money. You can turn it into a writ of execution. You can send a court officer to the place of business, or you can go after their bank accounts and take their money from them. There are things you can do, but no one said that because there's a law on the books, people are going to throw money at you. They're not going to. And the reporter who misunderstood how the law works and said, oh my God, it's outdated, it mentions telegrams. It also mentioned the mail. And I would hope that you'd understand how this works. That if I say, pick one of the following, 1, 2, or 3, you don't go, oh my God, I didn't want to pick one. I'm screwed now. 1, 2, or 3. You can pick 2 or 3. I didn't want to pick one. Damn. We're screwed. I didn't want to pick one. I mean, I know there are people who think I'm going overkill on this, but I find it annoying. So here's the deal. Federal Trade Commission cooling off period. It might apply if you entered into a sale in your home, high pressure sale situation, 3 days to cancel, and the cancellation date runs from the date of the postmark of when you got the thing in the mail. The problem is that even if you canceled properly, you may still have to litigate. Okay? It's kind of like a doctor saying, I know what's wrong with you, but we're going to have to operate. Really? Wait, you know what's wrong with me and we still have to operate? What kind of rinky-dink operation you running here? I thought doctors could just cure you. Isn't that what modern medicine does? It just cures you? Once you know what's wrong with somebody, can't you just cure them? Yeah, sometimes we have to operate. Okay? Lawyers, sometimes we have to litigate. That's how it works. So that's the situation of the 3-day rule. I hope I didn't confuse you too much. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.